Hello, everybody. I'm Rebecca McKinnon, founding director of a research program called Ranking Digital Rights and author some while back of a book called Consent of the Networked, in which I talked quite a bit about the new sovereigns of cyberspace, which is perhaps why I'm moderating this panel. And just thank you very much, Anupam Hao-Chen and everyone else involved in organizing what has already been an excellent, thought-provoking, and informative set of sessions this morning. And it's a real credit to the organizers that the panel that we're about to start on human rights and data sovereignty picks up right where the last panel ended, I think, with a further drilling down or discussion about what sorts of standards do we need to apply when we think about digital sovereignty. What is digital sovereignty? What types of digital sovereignty are legitimate? To whom? And many of these questions, and really leading me to ask, to think about the extent to which human rights standards, commitment to human rights standards, accountability to human rights standards can potentially form the basis for legitimacy of different types of digital sovereignty to the extent to which it is necessary and desirable, et cetera. So with that, I'm going to just very briefly introduce the three speakers. Their bios are available in depth on the website. We have Jen Daskal, professor of law and faculty director for technology law and security program at the American University College of Washington College of Law, and she's going to be talking about digital sovereignty, free speech, and the global information flow. Then we're going to be hearing from Kyung-Sin Park, who I know fondly as KS, professor of law of Korea University Law School and founder of OpenNet Korea. He's going to be talking about the conflict between data sovereignty, human rights, and trade norms. And then we'll have Susan Aronson, research professor and director of the Digital Trade and Data Governance Hub of George Washington University Elliott School of International Affairs, presenting her paper on inadequate data governance and how it's affecting national security. So really looking forward to these three presentations and what I expect will be a fascinating discussion and more ideas sparked that will really help set up the second day of panels. And again, thank you. I want to just give particular appreciation and thanks to those of you in Asia who are hanging in here at what is turning into an ungodly hour for this type of activity. So with that, I'd like to hand it over to Jen, who's going to have some slides. I think everybody's going to have slides, actually. And Jen will be talking about digital sovereignty, free speech, and the global information flow. Over to you, Jen.
Great, thank you. Thank you, Rebecca, and thank you to the organizers of this really, it's been such a terrific conference already. It makes me so very sad that we can't all be in person. I keep on having reminders of how sad that is, and this is definitely one of those key reminders. But hopefully 2021, by next year at this time, we can do something like this all in person. So as Rebecca mentioned, I am talking about digital sovereignty, free speech, and the global information flow. And what I'm going to do in this brief discussion is talk a little bit about various forms of digital sovereignty, and then delve into some of the less often discussed efforts to keep data out and to impose global controls on information flows as part of the efforts towards digital sovereignty. and then offer some analysis of the trends and suggested responses to address some of the more troubling aspects of those trends. Now, I think, at least for many, digital sovereignty is often thought of kind of hand in glove with digital localization, the idea that data should be stored locally in order to maintain sovereign control. And we heard a little bit about this morning already. And the examples of this are very well known, although they differ significantly in the purpose and form to some extent. So EU's transfer restrictions, which we heard about already this morning as well, which are encoded in the GDPR and limit the transfer of EU data out of the EU absent sufficient privacy protections in the country to which the data is being transferred, is one form of data localization. It's the rule that was responsible for the Schrems II decision recently, in which invalidated Privacy Shield and other mechanisms in place to permit data transfers from the EU to the US. And it's done in order to ostensibly protect the privacy and data of EU citizens and residents by keeping the data in. Other forms of data localization are designed to facilitate local surveillance, making it easier, obviously, to access and to demand access for data from companies and entities that are local and or data that is local. And data localization requirements also similarly facilitate compliance with local speech and censorship rules by, again, having access to the companies and or the data over which the efforts are being imposed. And so there's been lots and lots of discussion about data localization and some of the concerns about data localization. Now, the flip side of keeping data in is the effort to keep data out, to restrict what comes into the country. And then the other form of digital sovereignty is what I also think of as a form of digital colonialism, in which countries seek to impose extraterritorial limits and controls on content outside of their borders in order to protect and preserve the domestic flow of information into their borders. And so efforts to keep data out, a lot of these are extremely well known. The Great Firewall of China is the most obvious, but it's obviously one of many countries that are filtering data as it's coming in across their borders. Shutdowns of servers of particular services or services. Turkey shut down YouTube because of the depiction of Ataturk. There were various shutdowns by various countries of YouTube in retaliation for the showing of the innocence of Muslims in 2012. Vietnam last year shut down caches of Facebook servers for failing to respond to Vietnam censorship requests, and there's many, many more examples. But it's not just, these efforts to keep data out are not just efforts of what one might think of as authoritarian regimes or regimes that are in the business or thought of as in the business of censoring and severely limiting the kind of information that one's citizens and residents can have access to. So there's all kinds of other ways that a range of countries similarly engage in these efforts, and companies as well. So multinational companies that operate across borders regularly engage in various forms of geo-blocking. This is done in part to ensure that users in France get Google in French, whereas users in the US get Google in English. But these tools are also used and enable companies to offer up different experiences and to, as a result, comply with local speech regulations in different jurisdictions and offer up different versions of the information provided in different jurisdictions. Another form of what I think of as an effort to keep data out is something that Facebook put in place after the 2016 elections and obvious concerns in the United States about foreign election interference. Facebook, one of the measures that it adopted was to restructure some of its rules on advertising and, among other things, to require a domestic ID and address in order to place an ad, not just on electioneering issues mentioning, candidates or parties by name, but any issue of political importance, any issue that had some political resonance, whether it be refugee policy, environmental policy, questions of NATO engagement. And the de facto result was to restrict foreigners from being able to advertise across national borders on a range of issues. I had written this before last night, so I was going to talk about the recent bans of TikTok and WeChat, which were motivated or at least justified, ostensibly justified by a range of different justifications. But one of the justifications that was articulated was a concern that these platforms would be used by the Chinese Communist Party to spread their ideology into the United States. And of course, last night, these were followed up with a new ban on Alipay and a range of other Chinese-owned apps, which we can talk about more. Kind of fascinating and, from my perspective, rather shocking as well. And another example, just one more example, is in March last year, you had Senator Sass and Representative Gallagher demanding that Twitter restrict the use of Chinese accounts on Twitter because of concerns that China was using these accounts to spread pro-China propaganda and to spread false narratives about the political dynamics in Hong Kong. Now, whether or not we think, I'm not taking a normative stance on any of these, but just to highlight the range of ways in which countries and entities engage in efforts to keep data out as a means of preserving some form of digital sovereignty. And then the other key kind of newer development, I would argue, is extraterritorial efforts to engage in data controls as a way of imposing and protecting one's own vision of and one's own citizens and residents from what is deemed to be unwanted speech. And this is done through a variety of market power and power over companies. So the NBA dispute with China over a tweet is a classic example. The tweet's right here. It shows Daryl Morey, who tweeted out the rather innocuous statement, "Fight for freedom, stand with Hong Kong," that obviously then triggered a huge whole back and forth between China and the NBA, and the NBA distancing itself from the tweet, and China's Central TV and Tencent Sport canceling all showing of NBA basketball games for an entire year to a cost of, some have estimated that cost the NBA close to $4 billion, which is rather extraordinary. But it shows the power, the ability of companies, of countries, and to use their market power to shape speech around the globe, because clearly the NBA wants to have the China market and will be, I think, circumspect before engaging in these kinds of critiques going forward, even though China didn't get exactly all that it wanted, which was the firing of Daryl Morey as well. Another set of examples are the range of cases in which single courts or single nations have sought to demand that platforms adopt their local speech rules across their entire platform, thereby shaping the range of available speech, not just within the local jurisdiction, but in a range of other jurisdictions. And so I just put two examples of many, but one very well-known one is the right to be forgotten. After the European Court of Justice announced the right to be forgotten, or at least announced its version of the right to be forgotten, France demanded that Google apply this right, not just with respect to data that's accessible in Europe, but data that's accessible around the world, and went back to the European Court saying, we have the right to do this. The European Court in that case said, actually, the particular regulation on which you're relying doesn't provide for that kind of global control, but it basically provided a blueprint for the EU to rewrite the regulation that would allow for a single user to go to Google or another search engine and demand delinking around the world, or specified that EU member states could, in their own local laws, provide for that. That hasn't happened with respect to the right to be forgotten, but in the heels of the right to be forgotten case, a similar set of issues was raised with respect to an Austrian defamation case in which a user called a former Green Party leader a lousy oaf, a corrupt traitor, based on, among other things, her refugee policies. In Austria, that was deemed defamation. Facebook was ordered to take down the post. It did, but it did so using geo-blocking in Austria only. That was not good enough, according to the court. It was not sufficient to protect the interests and the rights of the Green Party leader who was allegedly defamed. That court case also went to the European Court of Justice. And in that case, the European Court of Justice says there's nothing in EU laws that prevent a member state from imposing these kinds of global takedown orders, sent it back down to Austria. And just 2 months ago, Austria, in fact, ruled that, yes, Facebook could be ordered to take down that post across its entire platform, and look for and keep off equivalent posts as well. These are just some examples of other efforts, other attempts for single nations to kind of set global speech rules using to take some of the language that was talked about in the earlier panel, a form of arguably some sort of territorial arbitrage. All right, so what does this all mean and what do we do about it? So I think just briefly, and I'd love to talk more about this, I mean, I think we really, there is, particularly as single nations seek to, or single individuals or single courts seek to impose their own particular speech rules on the rest of the world, there is a real risk of a race to the bottom, where the entity, the nation, which the most censorious rules will be the one that wins. And so there's a real need to kind of think through how one can effectively respond to that concern. And one aspect of that, I think, is an affirmative defense of the diversity of speech rules, of rules across borders. And I think this doesn't just apply to speech, but it applies to a range of the other areas that have been talked about in this conference, along with, of course, the need for baseline protections for core human rights. Another area where I think there's a lot of need for ongoing work is defining the line between malicious foreign interference and protection of free speech. And so, you know, particularly as there is ongoing concerns about election interference and the ways in which countries are using their control and their ability to speak across their borders to spread disinformation, misinformation, and interfere in domestic polities. We, I think, as a global community, need to do a lot of work to try to figure out where that line is exactly. And related to that, I would argue the importance of applying the rules equally regardless of national origin or national citizenship. So, for example, the Twitter's decision to take down a range of accounts stemming from the CCP were based on concerns about that the accounts violate, and the use of the accounts violated their rules on platform manipulation. Obviously, if you look back at the last election, it was not just the CCP that was engaging in actions that arguably violated Twitter's rules on platform manipulation. And we ought to be very careful about ensuring that our rules are applied equally to domestic actors and foreign actors alike. So I will end there. I see Rebecca looking at me saying that I'm going on too long. Thanks.
No, thank you. That was perfect timing. I just kind of slid in here just in preparation. So thank you very much. And again, as you say, kind of the baseline rules and to what extent should they be human rights standards? To what extent do we need other standards or mechanisms around that? So now on to Professor K.S. Park. Are you in Korea or are you on the US West Coast, by the way, out of curiosity?
Right now, I guess being a risk taker, I guess I'm in California.
Oh my goodness. I was hoping for your own safety that you were in Korea.
Well, This fast transmission, there's really no big place on Earth.
Yeah, I'll say. Well, in any case, thank you for getting up early then, and please take it away. We look forward to hearing your presentation.
Yes, thank you, Anupam, and thank you, Hao Chen, and other organizers and panelists and moderator, Rebecca, especially for our panel. I'm not going to spend time just piling on all the accommodations said by others. Start my presentation right here. Okay, let me see. There we go. Okay. All right. Conflicts between data sovereignty and human rights and trade norms in the case of data localization. Okay. All right, here you go. Sovereignty. When we say sovereignty, we are usually talking about state sovereignty. If you are talking about sovereignty of a person, we'll talk about freedom. But when we say sovereignty, we are talking about some institutional power, freedom. Stanford Encyclopedia of Philosophy lists 4 elements of sovereignty: the state possessing it, state possessing authority, which is derived from some source of legitimacy that is supreme and is exercised over a territory. Now, data sovereignty sovereignty first is often invoked as a remedy to colonialism. So the language of data colonialism begins with a phrase such as global giants holding and monetizing local people's data. Therefore, we need data sovereignty to stand up to that. And one of the prevalent forms of exercising data sovereignty has been data localization. If you look at if you look at the rhetoric carefully, sometimes national wealth creation using the data is emphasized. Other times, privacy. Although there is a question about whether local processing of data is better for privacy or not, and sometimes focuses on taxation. The rhetoric, especially in Korea, goes like, YouTube is making so much money off of our Korea market, but we cannot tax any of the income. On that, there's a question on whether we just need to ease the taxation requirement instead of invoking this abstract concept of data sovereignty. And also network usage fee, as if you are familiar with network neutrality, you'll know that local telcos cannot charge remote servers. And there, the nationalistic argument is also made that YouTube and Netflix are making so much money in the Korea market, and yet local telcos cannot charge Netflix or YouTube for usage of network, which actually should be free, which is actually designed to be free from the foundational days of the internet. Now, then we can define data sovereignty as efforts of national states acting for user interest to protect its subjects from imperial platforms' exploitation, and it becomes an anti-colonial fight. Of course, immediately the key difference is that these imperial platforms, if at all, exploit everybody, not just people in the periphery, but also people in the center. What I mean is their home countries, nationals. Then corollary question is, unless we are engaging in anti-capitalism fight, why do we need to localize? I mean, are local platforms at all less exploitative than these imperial platforms from the US? If not, then maybe this is just antitrust concern blown out of proportion. Or is it simply mercantilism, which is nationalism focused on creation of national wealth? I'm just asking these questions. I'm not gonna provide an answer to that because that's not my main concern. Now, I think I can save a lot of time because the previous speakers, especially Jennifer, elaborated on there's different forms of data localization. Now, GDPR's cross-border transfer restriction is a little bit different from data localization per se, because GDPR does not require data to remain on European ground. GDPR requires European data to require on the territories where data protection is adequate. So I think that this is more proportionate, if at all, proportionate data localization rather than nationalistic data localization. But it is a data localization nonetheless, because you are trying to control where the locality of data is. Now, US has no restriction, has had no restriction except the provision on Children's Online Privacy Protection Act. But recently, actual bans on Huawei and Alipay and threat to ban TikTok. These are new forms of data localization. It is different from nationalistic data localization, which is a requirement to, which is a requirement on the data to remain on the domestic soil, as in China, and it is not proportionate data localization like in GDPR, where the location requirement changes depending on how, in proportion to how well data is protected. But this data localization actually singles out one country, China, currently the US's economic rival. And the US has also worked out an exclusive deal with the EU back in 2000 through Privacy Safe Harbor, and later replaced by EU-US Privacy Shield. Now, what I want you to what I want to direct your attention to is the Cloud Act, which allows US law enforcement to obtain US companies' foreign servers data via warrant, but without the local warrant where the foreign server is located, and vice versa with a country that has executive agreement with the US. Now, there is this is kind of an extraterritoriality, right? This is this came from the urge that US police should be able to conduct legitimate investigation on US people, even if the data is located outside the US soil. So this desire for extraterritorial investigation is natural, because there's a gap between the desire for extraterritoriality and the ability to achieve it. And that has resulted in Cloud Act. What's the next step? Well, it would be even better if the data is localized within the domestic soil, or at least it's not located behind the Great Firewall, or in any country where surveillance cannot be conducted. I mean, for instance, there is no chance that the US and China will enter into executive agreement envisaged by Cloud Act. So I think the Cloud Act kind of anticipated these bans on Huawei, Alipay, and TikTok. I think this all comes from the sovereign's desire for extraterritoriality, at least in the case of the US. Okay, APEC, cross-border privacy rule system. I'm not going to spend much time on this. This is kind of a system competing with GDPR, and yet it also creates a quote-unquote safe space, excluding other countries where data is flown freely. Japan has been generally generous to cross-border transfer, adopting CBPR certifications, which exempt data subjects' consent for cross-border transfer. Recently, Japan, in Japan, in preparing for adequacy decision, made a special pact where the Europe-originated data will not be subject to CBPR exemption. China, network security law, you all know about this. Russia, you all know about this. Vietnam, I guess I'm just showing off the name, showing off what I know about the names of these laws, because you all know about what's going on there. Now, India, again, this overlaps with the previous presentation. There's a sectoral data localization. Now, my main topic is conflict between data sovereignty and human rights norms. Transferring data is speech. Collecting of data is knowledge. So regulation on data transfer is restriction on speech, and regulation on collecting data is restriction on right to know. And state sovereignty, therefore, can easily achieve brinkmanship to censorship on speech and right to know. And data localization, which is a manifestation of states' data sovereignty, risks censorship on speech and right to know. Having said that, even before, there is a Siamese twin to data localization, which is internet shutdown. We will all agree that internet shutdown is a form of censorship. Now, if there are different ways of exercising this censorship, and data localization has appeared as a means to achieve censorship without performing internet shutdown. Internet shutdown, especially website blocking. I'm not talking about network shutdown, which happens often in Africa, but I'm talking about blocking a certain platform or website where a lot of interactions take place. Internet shutdown, and on internet shutdown, at least the past 10 years, there has been incremental accumulation of international jurisprudence on how that should be dealt with, starting with the General Comment 34, Human Rights Council in 2012, and repeatedly until 2018, and UN Special Rapporteur LaRue has expounded upon the internet shutdown norms repeatedly. European Court of Human Rights also has ruled against internet shutdown or the likes of internet shutdown in Times versus UK, Eldirim versus Turkey, on Google, and Cengiz versus Turkey on YouTube. All these cases focused on the availability of extraterritorial space for people to speak. Also, Inter-American Commission on Human Rights, and also African Commission on Human and People's Rights. They also had, well, Inter-American Court equated internet shutdown to prior censorship, while African Commission focused more on network shutdown. And then there are famous cases from Turkey on Twitter and Brazil WhatsApp. This relationship between internet shutdown and data localization should be examined more carefully to really understand to deal with how to deal with these desires for control. Now, on a slightly different angle is when privacy is used as a basis for data sovereignty. Now, safely and fortunately, so far, the international jurisprudence has been that privacy trumps free speech and right to know. Free speech does not apply to privacy infringing information. Now, the bigger debate has been on what data is privacy infringing and what is not. Now, state acting as a, now data sovereignty ends up create a state acting as a guardian of its own national data subject. But immediately there's a question, is it consistent with the human rights norms when state act as a guardian? For instance, well, state act as a guardian only for its own national data subjects. Under Korean wiretapping law, surveillance on foreign nationals is not subject to warrant requirement. Is that really consistent with international human rights, where countries protect only the privacy of their own people in exclusion to others? And also data portability in GDPR strengthens people's right to move data from one platform to the other. But what if the receiving platform is in another country? What happens to the cross-border portability? So it seems as if there is data portability. If you include data portability in data protection becomes a concept in tension with itself. Also, extraterritorial search warrant or the other manifestations of desire for extraterritoriality, such as Cloud Act and Brazil's WhatsApp shutdown, which are efforts to avoid the MLAT process. This really is in tension with the one's right to choose through which platform, through where speech takes place, and right to choose where data resides. When we acknowledge that somebody's speech also is a personal data about him or herself. Now, data sovereignty and trade norms are also conflict with each other. Provision of content, apps, platforms is trading services. Blocking content, apps, platforms is, of course, restriction on trade. But there's a tweak here because many times the platform is provided to local people. Global platform is provided to local people with no money exchanged. So is this really trade? What global platform, where global platform is actually taking money is when they are selling the eyeballs to the advertisers. So it is really sale of advertising. Now, data localization is a restriction on foreign platforms' advertising services within countries. So now we can safely assume that this is trading services now under GATS, the user norms such as national treatment, MFN, market access. They are all governed under the unique voluntary system of GATS, where specific commitments either positively or negatively made by individual countries. And interestingly, already through Uruguay round, almost all countries have made positive commitment. Positive commitment means they open up the market on value-added services and computer and related services. So this already conflicts with the data localization. Not many people have looked at this. I wonder why. Maybe because WTO is pretty weakened at this moment. In conclusion, I mean, I'm not going to repeat, I'm not going to summarize what I've said before, but I'll just say something more abstract. When we talk about data sovereignty, I mean, what should be the focus? Is it data or sovereignty? When we focus on data, we are usually talking about privacy, but I think what's really going on is sovereignty. What's really going on is that we should focus more on sovereignty, because there is no guarantee that domestic soil is more protective of privacy than a foreign soil. Now, if we shift the focus on sovereignty, which is state power to control speech, knowledge, and privacy, data sovereignty as a concept in tension with itself. It's like replacing the global evil with the local evil, then maybe just as bad or even worse. And I think it's a then no-brainer that human rights norms and international norms, which are restrictions on state power, are will be colliding with data sovereignty. I think that, yes.
I'm really sorry.
Okay.
I do apologize. We did start a little late, and I failed to mark the exact time you started, but I'm pretty sure you're.
I think so too.
Over 15 minutes. So if you have a final sentence to say, and then I think we need to move on to Susan. And I don't know if the organizers will give us a little bit of wiggle room at the end for the Q&A, but fingers crossed.
Yes, then the only available justification, I think, is the only legitimate form of data localization. I think it's a proportionate type of data localization exercised by EU. I'll stop there. Sorry.
Thanks, and sorry again to butt in, KS. I think, you know, where you've landed is definitely where I'd like to pick up on the Q&A in any case, so we can get a bit more into into sort of how we apply international human rights standards to these frameworks as they evolve. But moving on to Susan Aronson, who has the distinction of closing us out as the final speaker for the day, and take it away, please.
I'm trying to start my video, but
your video is on.
I'm going to start by saying, okay, there we go. Thank you very much to the host and to the audience, and nice to see everybody, albeit not actually see them. But anyway, so what I'm going to talk about is a very different perspective, which is why do governments and people living in various nations see the risks of data differently? And it strikes me as we should be very careful to say that what we're talking about here is personal data. And getting back to Professor Cohn's question about is the distinction between personal data and non-personal data dead, I think that's something that we really need to talk about and be very clear about. So my paper is really only talking about personal data, and that personal data can be misused, weaponized, or stolen. But there is also the problem of proprietary data, which allows rules governing proprietary data, in particular trade secrets, that allows firms to control data and use it in ways that are not yet regulated and perhaps should be. So what I looked at is, why is it that the US has taken these strategies that other countries in general have not taken? Yes, Brazil banned WhatsApp, but the United States under soon to be departed leader Trump has done so much to review foreign investment in data-rich companies, banning apps, but yet Canada and Germany, our close allies, have not. And what I found is they're more concerned about their lack of control over cloud infrastructure. What worries me is that governments are not cooperating on interoperable policy solutions when these platforms are global. And as with Professor Park, it is a global problem that is leading to national solutions. Okay, so my research question was, why did the US government label some apps a national security threat? Was it based on the location of the app creator? Was it based on the app purpose or the volume of data taken? And how did other governments, I chose Germany and Canada, responded? Okay, so what I did was I actually did 5 cases in the original paper, which was published by CG, and included Facebook. In each case, the US government alleged, and I say alleged, but never completely showed, and this is understandable, national security risk. The effects of the risk were global, but the response was national. And this is qualitative research, but the cases provide a most different design, where there was variation across internet application, countries, and alleged effects on national security. So what are we talking about here? What is the threat? So the threat can be direct or indirect, immediate or gradual. It can be presented by foreigners or domestic citizens or firms, and it could be through all sorts of applications. Okay, so here's the mapping. To save time, I won't go over all of this, but the companies were Strava, FaceApp, Totalk, not TikTok, and then TikTok. Okay, so what was the US government response? So in the case of Strava, it was that the US and other governments banned use of wearables that had location tracking. With FaceApp, which is a Russian app, the US investigated it and said that, because it was collecting more data than it should, users should be warned about it, but it wasn't banned. Totalk, to me, this is the most interesting case. This is a messaging app created by the Israeli government for the UAE, and it is essentially a surveillance app. The US government has not banned or warned other governments about its dangers, but some app stores did ban this app. It is widely used throughout the Middle East. It's the most popular messaging app. And then, of course, TikTok. So to me, what was odd is that the response seems so out of whack with the actual problem, which is to strengthen data protection regulations or to ensure that anonymization is effective. Instead, the Trump administration, through the Defense Authorization Act, created a new law requiring review of foreign investment in companies with new technologies that hold large stores of data. So meanwhile, what did Germany and Canada do? Both of them focused on what German calls digital sovereignty and Canada calls data sovereignty. Canada wanted to diversify away from the US cloud, and Germany is creating its own, or let's call it the EU cloud, which is really what it is. So what struck me about this is that US policymakers, at least under the Trump administration, saw a problem in the what and the how. Who owns and how is data used? Canada and Germany were more concerned about the where and the how. And to me, all 3 nations need to rethink how they regulate the use of personal data, and in particular, app permissions. I understand that if you say you can only, if you were to create a regulation that said that a firm may only use the data that it collects relevant to its function, that might stifle innovation. But so that signals that the 3 nations, and I think most nations, need to cooperate on interoperable, trusted policy solutions. And to me, this is a huge governing gap that must be addressed. So control is key. And so we at the Hub have a grant from Tufts MasterCard the Institute for Data and Democracy to look at the mapping, to map the governance of data in 52 countries. Specifically, we are mapping personal, proprietary, and public data. How is it regulated? Who's innovating in terms of the regulation? And one thing that we found is that trade secrets are key. And we can talk more about the specifics about what kind of control that gives firms, what rules are clear and unclear. And again, but I do think proprietary data is an issue that people just don't think about enough in the mixing of data. They think that personal data rules are dominant. And yes, that is true, but the control of the data still resides within the firm unless there are specific licensing agreements. Okay, I am worried about the effects on innovation and access to information. And if you restrict data too much, you will reduce the value of data, and you could reduce people's willingness to share it. I don't think app stores are the right governors, but yet that's what we rely on these days. Another thing that we need to think about is the market for data, which to me is so much like corruption. It is opaque. Buyers and sellers don't know very much about the market. And I think we need to do more, as the Australian government and the British government seem to be doing, to look at that market. Okay, I'll shut up now, and thank you so much.
Thank you, Susan, and thanks to KS and Jen also. Anupam messaged me to say I would get a little bit of wiggle room here, so we won't get shut down immediately in 10 minutes, and perhaps we should have a little bit more time to the extent that participants would like to hang with us for an extra 5 or 10 minutes. So just, this is so rich, these three presentations building on the discussion from the previous sessions. And, a lot of this, discussion of digital sovereignty, whether it's sovereignty of private data controllers, as it were, or apps or, entities, or sovereignty of nations. One of the issues around standards has to do with legitimacy, right? Who confers legitimacy in the setting of standards, in the enforcement of standards, in the coordination of standards. And of course, human rights would seem to be a very important component of that, or I think that this panel probably agrees that it's a good starting point. And I'd be interested in some comments, and I guess I want to suggest perhaps an initial starting point for a framework around legitimacy of data sovereignty that might be grounded in human rights. To what extent do you think that a way forward might be to say that sovereignty around data, in other words, the right to set laws and rules and to enforce them and to coordinate with other sovereign entities around those rules, requires a legitimacy, if it wants to be, if this sovereignty wants to be considered legitimate by other players in this global data ecosystem, there must be commitments to fundamental human rights norms to uphold and protect fundamental universal human rights norms. But then there also must be accountability to those commitments, which would involve not only having rules that are consistent, both when it comes to privacy rules and other rules around content that are consistent with international human rights norms and protect human rights. So privacy law and privacy, meeting certain privacy standards might be part of that. but also requirements around transparency. You need to be transparent about what your rules are and how they're enforced, and that you need to be doing human rights impact assessments around your rules and their enforcements, and that there need to be third-party audits or some kind of third-party verification system to ensure that you are actually doing what you say you're doing in relation to upholding and protecting the human rights of human beings who are either the data subjects or publishing speech, communicating, and so on. So I'm curious to what extent the three of you think that that some kind of that what we need to do is perhaps establish some criteria for legitimacy, and that might be helpful in moving forward in setting standards and mechanisms. And I'm also my second kind of round of questions, I'm just going to throw it out now in the interest of time, but people can either answer at the same time or later, or I might bring it up again later, is just given that we have a new administration here in the United States and an opportunity to reboot a little bit, what do you think the Biden administration should be doing, especially those of you who are focused on US, but also other democratic governments? So for instance, KS, if you had your dream Korean government, what should they be doing? Or, you know, what should, you know, it'd be interesting to hear what other participants feel, say, the ideal democratic government of India or other countries should be doing in terms of setting standards and creating regimes of coordination that would actually respect and protect people's rights around the world.
Rebecca, I'd like to take that first. One thing I'd like to say that could be helpful is to have a generic, rather than the right to privacy, or we've appointed special rapporteurs who are focused on specific rights writ large. And I think we need to think about this in two ways differently. Thinking about it in terms of a wide range of human rights, from freedom of association to freedom of speech. As Professor Park has said, privacy has taken, or personal data protection has been the focus of most governments. And I think that's unfortunate and to the detriment of the other human rights it can affect. The other problem is that we live in monopolistic and oligopolistic markets. The role of these firms that are so much bigger than governments and have so much data that we know nothing about what they have is a real problem. Regarding the Biden administration, I would say I have an op-ed coming out in Barron's about this, which is basically about DIPA, which to me, none of these trade agreements are really very good, but it is probably the most human rights oriented trade agreements that I've seen. Here's why. It's all about trust. And if you read the text, it's 65 pages of saying that there will be no digital economy if we don't collaborate and if we don't build trust among what they call consumers. So while its human rights focus is very generic in terms of trade as a commercial activity, it's the best approach I've seen so far in recognition that governance is at bottom about trust between market participants.
I can say something too. I think that data localization can obtain legitimacy. I mean, legitimacy is not obtained in vacuum. It is obtained in some sort of governing body, some institutional overarching scheme. For instance, in Europe, European Court of Human Rights will probably quickly a rubber stamp, I mean, I'm not going to say rubber stamp, will approve how this privacy proportionate data localization under GDPR is legitimate. I think they'll approve that. Now, I mean, we look at a lot of we find a lot of human rights abuses, including data localization in China, but we don't see any evaluation coming out of that because Asia lacks the regional human rights body, unlike Africa or America and other continents. I think that if there's an opportunity to address that, I think kind of domestic only type of domestic only type of data localization will not fare very well under international human rights standards. And I think that the U.S. actions against Huawei, TikTok, and WeChat, threatened against TikTok, I don't think they will fare very well if it is brought to WTO either. It is singling out a certain country based on the practice that has not been proved. I think that I mean, that was my last comment in that was my last comment in my presentation, which is that privacy, I think, is the probably just about the only basis of legitimatizing data localization against human rights norms and trade norms. And I think that we should look at carefully how that's used or abused or promoted by EU to spread around the world. I just want to make one more intervention, which is that if it's really privacy related, we should look at, for experts, we should really look at carefully data portability and how that's going to fan out. I mentioned, because data portability strengthens one's right to locate your data. And yet GDPR itself has a provision restricting that transfer. I guess data portability by itself, I mean, under GDPR, data portability will trump the cross-border transfer. I'm hoping that it does, but there will be situations where data portability will be blocked by cross-border transfer restrictions under other data protection laws mimicking GDPR.
Yeah, if I can just jump in as well. Thanks, Rebecca, for the great question. And it brings to mind, I mean, I thought Anupam's discussion earlier about the difference between Pompeo's discussion of the Western internet or the Western internet agenda versus, or US internet agenda versus the Hillary Clinton speech was interesting. And I've been spending a lot of time thinking actually about the Hillary Clinton speech and her quest for this promise of internet freedom and the internet freedom agenda, including what Anupam talked about as the freedom to connect, as contrasted with the authoritarian vision of the internet, and made two predictions in that speech that Anupam talked about, that on the one hand, internet freedom would lead to prosperity and freedom of speech and rising of dissidents and reduction of conflict. And on the other hand, authoritarian regimes would be inevitably, struggling and subject to decay and stagnation because they wouldn't have the full flow of information that would allow them to flourish. And I think we've seen in a lot of ways that both predictions have turned out to be completely wrong. And to go back to Rebecca's question, and I do think there is a real need and hopefully an opportunity that the Biden administration will seize, working with partners to put forward an internet freedom agenda that reflects the reality of an internet that is not just a place where freedom flourishes, but also a place where lots of harms flourish as well. and put forward a model in a way that connects a range of I don't think it's West. It doesn't have to be us versus them, but entities and groups and governments that share a common commitment to democratic systems, to diversity of voices, to protecting individual rights, to allowing dissent and disagreement, and that is, I think, the challenge for the next decade. But we can't wait a decade. So I hope that it is something that the Biden administration takes on really strongly, really quickly, and I think it's urgent, personally.
Yeah, and as Susan was talking about, there's one of the challenges also with internet freedom is the need to address the excessive power of a small number of platforms, because having failed to do that in sort of Internet Freedom 1.0, Internet freedom has been about making the internet free for Facebook and Google and and Amazon to do whatever they want globally, and to profit from the world's internet users' data globally, which some friends of ours speak to as a form of data colonialism. And so how do we ensure that as we're thinking about sort of not just sovereignty, but participation and legitimacy as well, which I think is ultimately part of that. How do you ensure that people all around the world have an opportunity to have some agency over what happens with their data, how it's processed, where it's stored, who prioritizes their speech, who is prioritizing what they see from their friends and people in their communities online, who's exercising power over their information environment, and how who is regulating that power to what end, and if we don't address that in a way that enables people in the global South to feel that they have some control or some ability to shape their digital environment, then I think we're going to see a great deal of support for the Chinese style concept of digital sovereignty with national borders, because people will feel that they're kind of being acted upon by colonialist, mercantilist, multinationals from the West, which and having their elections manipulated. There's a great book that I read recently on sort of election manipulation in Kenya via Facebook, and how various corporate actors really robbed people of agency. And so again, how do we get through to the other side in a way that does not look completely cynical? And unfortunately, there is a lot of warranted cynicism around the world, in the global South, from friends in India, from friends across Africa, from friends in many places, about the U.S. internet freedom agenda, even from people who are very opposed to authoritarianism, who are fighting daily for their right to speak freely online. Tremendous cynicism about the motivations of Western and also American as well as European government regulators or actors in this space. So I don't know, any closing thoughts on any of this? KS, maybe?
I think one topic that repeatedly came up in question and answer panel is the availability of antitrust concerns as a reason or legitimacy for data localization. I think that in terms of the desire for control, I think is related to antitrust concerns. However, in remedying that, it really goes against the grain of antitrust law to draw the lines on the national territories to bid against abuse of dominance. That's the term for monopolizing in the European antitrust law. Drawing the line along the national territories is not the really way to go about in addressing those antitrust concerns. And right now, antitrust scholars are developing new ways. The UK has done a pretty good job, which was mimicked in the Digital Markets Act that just came out of the European Commission. They're busy coming up with a new standard, new antitrust standard applicable to digital market, because so far, because of a low entry barrier and because of the fact that most services are provided for free, antitrust law has not been properly applied to digital giants. But now, we are thinking of ways to apply that. Then may, I think, reduce the desire for data localization, at least in the countries like Korea. I'm thinking about non-China, non-US, non-EU countries that are playing with the idea of data localization. In those countries, I think it will reduce the desire for data localization. So I think the antitrust concern is a valid discussion we should have.
Jen and Susan, final words?
I think there's a lot of work to do. Hopefully, so.
Thank you, host and moderator.
Yes, thank you, everyone.
Thank you, everyone.
Thank
Also for
you.
listening.
We could sit around, if this was a physical conference, we could now go off to lunch or to the bar, depending on what time zone we're in, and continue talking about this. And sorry, that's not possible now, but hopefully in the future, these are great organizers who've put together such a great group will be able to bring many of us together in a real space, and we can chew over some of these questions further in a more informal way. Thank you very much, everyone.